Welcome to the 16th episode of the Constitution of American Life with us. Yes, the 4Bs. Again, I am your facilitator, David Richmond, a former high school teacher of 35 years with the current high school district, where I spent the bulk of my time teaching government and civics and participated as a teacher coach in the We the People program. As always, we have Professor Tim Moore with the Center on the Study of the Constitution at the University of Wisconsin-Madison. And he as well, for numerous years, was a teacher coach in high school in the We the People Citizen the Constitution program. We also have another outstanding teacher from the We the People program, Professor Chris Kavanaugh, who currently is residing in North Dakota and teaches in. And Chris, I should know this because never mind. I don't want to say anything that might offend people of North Dakota. But you're in Bismarck, correct?
Correct. Yes. State
yes,
capital.
You teach at a high school in Bismarck. But for the bulk of Chris's career, he taught in near Indianapolis, Indiana, and he has been nationally recognized as one of the outstanding civics educators in the United States of America. And then finally, we have the puppy of our group, and that is Dr. James Michael Williams from the University of San Diego Political Science Department, who is in fact an alum of the We the People program. He was actually a part of what we call the pilot year, in which teachers were asked to pilot the program in 1986, 87. And he also was probably one of the most popular scholars used in the We the People national program in their professional development program, an outstanding professional development program that they had for many years. In today's session, we're going to be addressing what I would label the nebulous concept of the right to privacy. Students are being asked to address a quote by Sam Warren and the illustrious Louis Brandeis from an 1890 article. And here's the quote that we want to kind of deal with tonight that students have to address. Quote, that the individual shall have full protection in person and in property is a principle as old as the common law, but it has been found necessary from time to time to define anew the exact nature and extent of such protection. This was one of the first legal commentaries on the right to privacy in American constitutional history. Many scholars, starting in the late 20th century, identified privacy as the issue, all right, of our time, of the late 20th and now the 21st century. And there is no doubt here in the year 2021, we and the world community are confronting a myriad of controversies associated with the right to privacy. Although the early history of privacy is somewhat, in the famous words of Professor Moore, fuzzy or squishy there, in the modern era, there's no question of its importance. Over 150 national constitutions mention the right to privacy. Article 12 of the UN Declaration of Human Rights clearly protects some forms of privacy. The challenge, however, is complex for not only the nations around the world, but for us here in the United States. First, how do we even define this term privacy as a right? Secondly, how do we apply this privacy as a right? And thirdly, what reasonable limits can we put on privacy rights? So let's begin our discussion tonight with Professor Tim Moore. It seems to me, Tim, that Mr. Warren and Brandeis are implying that the right to privacy has been around. It predates our Constitution, our revolutionary period. Do you agree with that? That privacy is somehow in the conversation of British common law and American colonial law?
Well, no, I don't, if it's defined as a right. The quote, I actually read the whole article today in preparation for this. And it was fascinating because in the quote itself, it says principle. And I think that's an important word. And I think it's, having read the article, I think it's an accurate word that the principle has been around because Brandeis and Warren go through all of the phases of history and in American history and say that this principle of privacy, as they were in the stratospheres, how wonderful the evolution of law is, and how it was like almost breathless, their admiration for the evolution of law, and how this principle has been adjudicated, and in different, and a lot of it's redefining property on how it needs to be protected and should be considered private possession, the role of technology. So they go, the article goes through a lot of iterations of how the principle has been interpreted in various contexts. And likewise, at the founding, there's no right of privacy, but the principle is there, but it doesn't scream real loud. It doesn't have neon signs, neon lights, but there is this notion of privacy. Now, certainly not the principle. I would contend that the principle at the founding or in colonial wasn't this internal, individualized privacy concept that we have now. But there was a principle of privacy, yes.
Well, let me ask you, and I'm actually going to reference the We the People, the Citizen, the Constitution textbook. I don't know if it's this version, or I know it's definitely an earlier version. They said that the whole idea or construct of constitutional government, that in order for a government to be constitutional, it had, and I liked how you phrased it, the principle of private domain, that constitutional governments have to carve out an area of the citizen's life in which the government has no business whatsoever of involving itself in. So, and I'm just curious, based upon your studies, is the We the People text, is it accurate on that? And is that kind of what you're referring to as principle?
Yes, probably. I've not looked at the text lately, but I think that's probably accurate. I mean, what struck me when I reread this article is how much the privacy concept was tethered as a property right. Like I publish something, it's my private possession. So a lot of the interpretation in the 19th century was tethered to the idea of property.
So, I mean, would you?
No, go ahead.
Yeah, well, no, go ahead. Well, Chris and Mike, thoughts about that? Again, I'm curious, about this notion, and Mike, since you're in comparative government, this notion of, and like I said, it was clearly enumerated in a previous edition of the We the People text, these characteristics of higher law, which makes a constitution constitutional, is that there's this area of private domain there. I'm just wondering, and I know political theory is not your area, but I'm just wondering if that's where somewhat Brandeis is referencing here, this principle of private domain, this rather than a right, it's a principle. Do you kind of agree with Tim on that?
I do. I mean, I think that comes out of the Enlightenment thinkers, right? I mean, there's this big distinction between the public and private domains that I just, based on what Tim is saying, it's kind of in the air they're breathing, but it's still interesting. There was a lot of things in the air that they were breathing it was still important enough for them to put it in the text, right? And I still not sure I quite understand why something this fundamental to a constitutional government doesn't show up in either the text or doesn't show up in the Bill of Rights. I just find that curious, and I don't know. I don't have the answer to that.
Chris, thoughts about?
Yeah, I have several. And gosh, and I'm really like I'm asking to get a severe beat down here by pushing back against Tim, who I actually kind of alluded to in class today about. I said a friend of mine talked about historian and presentism, but that's a different story. And I'm going to go to Tim's close friend, Professor Akil Reed Amar. And I know Tim and Professor Amar are well acquainted. But Professor Amar talks about the actual word itself, privacy. And the word privacy in the 1600s and the 1700s really wouldn't have been used. you would have the questions about secure in one's, like some of the language we actually have in the Fourth Amendment. They use it to be secure in something. Privacy itself would have been the privy. And what that means, students for watching, the privy would have been the outhouse or the necessary, right, to visit the bathroom. So you wouldn't use that word privacy. And I would also go back as far as like 1604, in this case called Siemens case. Starts Semayne apostrophe S. And one of our favorite guys, Sir Edward Cook, this is spelled Coke. And this begins the castle doctrine, right? So to be idea for someone to be secure in someone's home. And he has a great quote, and I've always butchered. He says, "No matter how poor a man's shack may be, and no matter how the wind may whistle through it, there are places the king does not belong." Coke loses that case. The Siemens case from 1604 in England goes back to common law. So I don't think they would have used the word privacy. They would have used the word to be secure, right? And the idea of where now, of course, we're getting into warrants, and hopefully many of the students are aware of the idea of general warrants and writs of assistance. You guys have probably been through that in your studies. So I think then you're going to see that morph into a modern concept with using the word privacy.
Yeah.
So, Chris, go ahead.
I just want to relate that back to what Tim was just saying about property. I just couldn't help but thinking about Locke, right? And Locke's notion of how we get private property, right? And it seems like he takes as the assumption, I would use the word autonomy. Like there's like an autonomy, but then when you put your labor into something outside of your autonomy, that's how you get private property. So I just think it's interesting that this notion of the house, as we always focus on the castle of the house, it is very property sort of oriented. And I think that, again, I think that goes all the way back just to how we take those steps to think about individualism and then property and then what's us and what's ours and what's someone else's.
So,
Sorry,
no. That's actually a good transition to. I want to ask Chris. In my research, like I said, I was overwhelmed with the body of literature on the right to privacy there. But U.S. law generally lays out privacy in 4 distinct categories. And partly I'd like you, Chris, to maybe comment on these and clarify if necessary. One is the right of persons to be free from unwarranted publicity. Secondly is the unwarranted appropriation of one's personality. Thirdly is publicizing one's private affairs without legitimate public concern. And lastly is wrongful intrusion into one's private activities. Now that's what I came up with, and I'm just wondering, are you comfortable with those being a good spectrum of the areas of privacy? Would you rephrase them differently? Would you add or refine anything about those?
I think those are good. I think the last one you listed, I think, is the one that students are most familiar with, and that's really where they're going to find most of the case law. That idea of like creating that barrier. But I would add a category, and I think this is a very modern thing, and that is data privacy. Do you have a right to your electronic data? So when I leave footprints, when I'm online, I just got done ordering a sweatshirt, right? Do I have a right to my data? And for the students watching, and we'll put this in the links later, there's a great documentary that you can get on Netflix. It's called The Great Hack, and it deals with the Cambridge Analytica, the idea that our data is being sold and manipulated and used by private actors. And do I have a right to my data? Is that private? Is that part of back to what Mike was saying, is that part of my property? Do I own that, or by simply logging in, do I lose that right? So I think that's a kind of, I don't know, it's right now. It's not the future, it's right now. But I think there's a place in terms of it being adjudicated. There might be to take a look at where the lines need to be drawn on. But for your other categories, I'm good.
Well, I'm curious because I'm wondering, Chris, if the second and third one, don't they kind of deal with that, the unwarranted appropriation? of one's personality. Isn't my personal, data an expression? Is that, because that's how I understood that second in
Well,
the
that's,
list that
I
I
think
gave.
that goes back to the idea that can they put Dave Richman's face up on a billboard, in Bakersfield? And no, they can't. I mean, if a private company wants to do that without compensating you, right, without drawing up a contract, they can't do that. The other part of that too is public figures. Are public figures that are in the limelight, are they more fair game? I think that goes back to a case I mentioned before, was Sullivan versus New York Times, or New York Times versus Sullivan, which is a really good case for that as well. Public versus private people. If you're a public person and your name is out there, or a celebrity in the limelight kind of thing, this is where I think for students in this area, it'd be interesting to take. And I don't know the libel laws, but I know the libel laws in England are much stricter than they are here. So the tabloids in England, I think, will want to publish more things about celebrities because they know that they'll get slapped down by the courts.
So are you saying that the list I gave you is devoid, and this would make it a really bad list then, is devoid of anything to do with technology? Because again, I look at the third one, publicizing one's private affairs without legitimate public concern. I know kind of the narrow way we would see that, but to broaden it out, the release of my data, all right, not in the general public forum way, but the fact that these tech companies, share my data, with other people, companies, advertisers, things like that. Is it implied under the third factor, or no? You're thinking this list is totally devoid of technological questions of privacy.
It might fit in the fourth. In the fourth
Wrongful
category.
intrusion into one's private
Yeah, I mean,
activities.
algorithms may be the undoing of us all. And it wouldn't be government; it'd be just private. I mean, to Chris's point about, do we own our data? I mean, it could be algorithms is the big problem. Go ahead, Mike, because I had an observation about the Gilded Age, how it applies here. But
go ahead.
Go ahead, Mike.
No, I want to follow that. Go ahead.
Okay. That list is fascinating, David, because each one of those, I kind of hear vestiges of some of the issues of privacy in the Gilded Age. Corporations were resistant to antitrust sentiments and claimed that their data, their information, how their businesses operated were private. Victorians were unsettled by some of the yellow journalism, the sensationalism in the press, wanting to report on their daily activities. That kind of sounds like 3 or 4 in the list. So the Gilded Age, I think, offers some interesting insight as to the interplay between privacy and technology that I think probably would apply in a modern. I mean, imagine that it's something in the Gilded Age applies to now. So that list was quite fascinating to me as you went down there, because I heard some issues that were raised in the late 1800s about privacy. I'm sorry, Mike.
Yeah, I think I'm going to build off that. What I found interesting about the list, David, is that it seems to beg the question a little bit. It feels like we're saying, well, what's private is anything that isn't public, and anything that's public, right? It's just like we're using the public-private distinction. It still doesn't get us to what is a private activity.
Right.
I mean, and to me, that comes down to, I think we have to bring up the issue of expectations, like what would a reasonable person think is a private activity? And then the fact that, like, with all this technology, to get to Chris's point, or in any of our, like, I know at USD, right? All students, when they walk into USD, they sign a consent form that says they're giving away their ability to have control over their photo. Like, USD can use that, right? I think that's kind of common. So there's this other idea of consent, right? That is, as much as we want to like play around with what's private or not, we very quickly in this day and age, we all consent to so much, whether we get on any of our devices, we don't even know what we're consenting to. So I don't know if we're engaged in private activities when we're online, because we've effectively given up that claim by signing away and saying my data is now being owned by Verizon or whoever owns it, right? So I don't know. I kind of went circular there. I'm just trying to
No,
point out
no.
how it's really complicated to get at what this definition is, which is where you start.
Well, okay, so I'm curious from the political scientist point of view, how would you define it? How would you define this right to privacy? Is it personal autonomy, i.e., the zone in which I get to be me and government, and that gets a little bit more complicated today, which we'll talk about later, but government has a hands off,
Yeah.
towards my, persons, places, possessions, unless they've got some kind of legitimate. Is it that simple? It's just personal autonomy, and government doesn't have a reasonable interest into invading that. Is that a political scientist definition, or just a Richmond?
I don't want to, I haven't attended the political science meeting in a while, so I'm not going to claim I have the definition for all of us. But
Good for you. Good for you,
yeah,
Mike. You haven't been in a while.
Yeah, I think it's
Okay.
I would say it's the right to be left alone, unless I wouldn't say reasonable. I would say unless there's a compelling interest to not leave me alone and to leave my stuff alone. I think that's the way I would define privacy.
Okay, so I didn't know if I was, going to go there. So those who are anti-vax, don't they have a very, very, very legitimate argument? They want to be left alone.
I think that, again, it's does the government have a compelling reason to not leave you alone? And this is where we argue facts. We argue the principle about, is a pandemic a compelling reason that you would give up some of your autonomy for the good of the public?
And that was the third statement, David. There's this thing called privacy, but there's this other thing called public benefit or public purpose.
Public concern.
Sure, yeah. So I think that claim would run afoul of point number 3 in your rundown of the 4.
So you think it was okay for Mr. Rogers to be forced to go public there in Green Bay about his vaccination? And that's not a private issue. That's a private medical issue. What interest does the public square have?
Right, but he floats around in the public, so it automatically becomes a public issue. So we don't live in an isolated world. We live in a very interconnected world. So there's a lot of things that automatically, very quickly, become public issues. What I do want to, and I realize there's some problems with that statement too, but I was intrigued by your second statement that your privacy is invaded if somebody's appropriating your personality. I have no idea what the hell that means, because I'm pretty sure my personality has been appropriated. I think, I don't know, maybe it hasn't. That sounds really, did that strike anybody else as potentially bizarre, or is that just me?
Well, I think go ahead, David.
Go ahead, Chris.
Well, I think and I don't know this, but I think I know from where it stems, that the idea is more of like where you're moving into the realm of commercial speech. And so if you appropriate someone's likeness or personality without their permission, right? So if you're a celebrity and I'm doing commercials, I'm like, I tell you, I'm doing my best Rodney Dangerfield. He's an old comedian, folks. He's passed away, so you kids can look him up. He's pretty funny.
Well, I also think the NCAA O'Bannon issue using college athletes image would fall, without the, and they don't get compensated possibly.
Right. But the personality was that just was an odd word to me in that.
Well, I've got about 100 pictures of you, Mr. Moore, and those pictures say a lot about your personality. There, and we'll just leave that there, but I just wanted to say that a picture can tell 1,000 stories.
Yes.
Yes. Mike, the students have to deal with, and I like it that in a unit outside of Unit 6, they're asked to have some kind of international perspective here. And as I stated in my opening, which kind of surprised me, 150 nations have a right to privacy either implied or enumerated in their constitutions and the UN Declaration of Human Rights there. But I'm curious, based upon your experience, your understanding, your studies there, do most of these nations treat privacy and your understanding similarly to the United States, or are there any distinctions internationally of how countries deal with privacy?
Yeah, I mean, again, we've talked about this on other sort of segments, but this is where the United States is kind of leading the way on maybe not how to do it, how, to show that there's a better way. I mean, as you mentioned, David, there's a few countries. I mean, India's one, Australia's one, where there's no right to privacy in the Constitution, and courts have recognized the rights. But you're right, most countries have some sort of right to privacy in their constitutions. But what they do, and again, because I study South Africa, I just listen to what South Africa does, because they kind of take a few of our amendments and they fold it into privacy in a way that I think makes sense, right? So in South Africa, the right to privacy is, or the right not to have their personal homes searched, their property searched, their possessions seized, or the privacy of their communications infringed. And what the South African Constitution also does, instead of leaving it up to courts to set up how do you limit rights, they set up a test and they say, if you're going to limit any of these rights, here are the steps that the judge has to, or the government has to go through to do it. So to me, it's an easier way to see like what that right to privacy would mean, rather than the way we've done it in the United States. And I know Chris and Tim can talk much more about this than I have, is we've had to cobble it together out of sort of the what Sue Leeson used to call the small C, the sort of like the culture, and to read it into the amendments and things. So that's the main difference.
Don't a lot of post-Soviet constitutions articulate bodily autonomy?
They do.
And is that because the medical testing, like the experience with totalitarian abuses medically? Am I right on that this bodily autonomy thing pops up?
You're absolutely right. And it comes up, you're right that out of the post-Cold War era, a lot of constitutions are responding to sort of the brutalities that they had during that time. So sometimes it doesn't show up as like privacy. Like in South Africa, there's a right not to be detained. And it comes specifically, I mean, and you might see that as a privacy right? You can't detain me, but it's a specific different right. And it comes out of the fact that the apartheid government would regularly just, lock people away for years and years without any sort of crime being leveled against them. So, yeah.
So I guess that transitioned us, Tim, to the American constitutional experience. And it was interesting because you framed it, at least historically, that it's predominantly property. And if we look at the Bill of Rights, I'm just wondering how you would interpret the Fourth and Fifth Amendment, where I think there are these, penumbras of privacy, unreasonable search and seizure. That's beyond property to some degree, your body and stuff. So I guess what I'm asking you is, where would you find privacy in the American Constitution and specifically and the Bill of Rights there? And again, I guess if indeed Brandeis and their article in 1890 is accurate, the question arose to me is then why isn't privacy enumerated in either the Constitution or Bill of Rights? I'm curious about that question. So I know I gave you kind of a two-part question there.
Yeah.
Where would you go if you were an advocate of privacy in the Constitution? And
well,
secondly,
I'll punt and say see Griswold. I mean, because the court is, if I'm remembering this correctly, there were 4 or 5 different opinions where it was in the Constitution. You had Goldberg, I think, who said it was the 9th. Others said, maybe it's and to your point, the 3rd and the 4th. I think it was Stewart and White who said it's 14th. But then that forces them back to the first 8 amendments as to where is it there, so it's incorporated. So the much smarter people, I think a lot smarter people than me, have wrestled with the idea of where it actually is in the Constitution.
Well, Griswold deals with personal autonomy, but
right.
I mean, there's previous cases on privacy, and that's more Fourth Amendment, right? Isn't there a 1920s?
Well, yeah,
I'm sorry.
Pierce versus Society of Sisters and Myers both had to do with families' privacy and the decisions of how their children were to be educated. But the interesting thing in the 1800s, there also was this this issue between the biggest threat to privacy for people was the Census Bureau and the post office. There was a tremendous fear. I was reading some of this stuff over the weekend, and it was remarkable again how a lot of those fears in 150 years ago resonate today with our continuing fear of large government agencies. But the census and the post office were really the violators of personal information.
Well, I'm curious, and Chris, you might be the one to go to on this. So you've got Pierce, and I'm just wondering what their argument is in Pierce about this zone of privacy. And then I think I was referencing, is it Weeks, Chris?
Well, you got a whole plethora of cases that slowly work to eventually incorporate the Fourth Amendment protection against states as well, because you've got Katz, you've got Olmstead, you've got Wolf.
Okay.
You've got a number of cases, and I think it was, David, you mentioned this earlier, which sent me scribbling some things and looking about this expectation of privacy, right? So this expectation of privacy, and there's a lot of, I mean, I think it's is it Katz, the guy in the phone booth, right? Katz is where they're tapping the phone
Okay.
booth, and it's spelled the K, students, Katz, and the guy's a bookie. And the court is talking about, does he close the door on the phone booth because he has an expectation of privacy? This is for the students. This is like the original, drug testing case, which we haven't even talked about, which is Vernonia School District. And they started drug testing athletes. And one of the things that the court mentioned was for athletes to have a lower expectation of privacy because they change in a locker room. So because they suspected that was the football team that was doing the dealing at school, right? If you get into the details of Vernonia School District v. Acton, I think is the case. So you talk about this expectation of privacy, and what we have is just oh my gosh, this is so much case law in trying to winnow this down of what that is and how far the government can go. And it's tied in with search and seizure because it is a Fourth Amendment issue as well. And you all the way up to what Tim mentioned, of course, is Griswold that finally writes about this expectation or this idea of privacy with a P, privacy, as opposed to security, going back to my comment about Amar.
Well, I guess,
now,
Chris,
the second part of your question, David, I mean, if you want to still address that, why isn't it enumerated? Okay. Well, as I've said in previous episodes, I'm a bit jaded on the 9th and the 10th Amendment as to whether they're
yeah, I know you're jaded, but
all that in a bag of chips. But and largely because of what he said about the project of doing the Bill of Rights to begin with. I think in a letter right towards the tail end of the discussions in Congress about what he called the nauseous project of creating the Bill of Rights, he basically writes, I think I've got it here. He writes to Richard Peters, and he says, look, the reason we have the 9th Amendment is, and he basically says it's like an old Federalist argument from ratification, and it's basically there to shut them up. So
what? No, hold on. Does that mean we're not supposed to use it?
Well, no, that's a different question. That's a different question. All I'm saying to the question of why didn't they enumerate it, my answer is because Madison didn't really want to do the project to start with. Now, to your point, Chris, that's a fair point. If it's there and it's in the text, you kind of do have to use it. But
Right,
why
but-
it's there may influence your commitment.
Because I was about to call you Robert Bork for a second.
Well,
he looks a little bit like Bork.
there could be worse things.
He needs the wild hair. He had the wild hair.
Right, yeah, but
You see,
this looks like Bork.
you're appropriating Bork's personality right
That's
there.
right. That's right. That's right.
No, but no, I think Chris and I want to go down the same path. Okay, I'll grant you that maybe Madison's flippant. He's tired with the project there, but he writes these words. These words are supposed to have meaning. And it seems to me that, and this is, and Chris, I do want to transition to what you said. This seems to be somewhat of the problem in the 20th and 21st century, but I've always seen it very clearly that privacy is embedded in the Ninth Amendment. All right, they didn't enumerate it, but they didn't deny it, and again, they left it to future, generations to enumerate those.
But the fig leaf is really small. That's a very, very small fig. When you compare that to the third, if I was going to say, you put me in the corner, where is it? I'd say third and fourth, because the principle is clearly articulated. It's clearly the principle is clearly articulated. The Ninth Amendment, what does that say?
Wait, the Third and Fourth Amendment clearly articulate that in a system of accused persons and criminal justice.
That's why I said principle. That's why I said principle.
Yeah, I don't know if it deals with personal autonomy. All right.
I would agree with you there. That's another leap.
And so when we get to Griswold, which has much more to do with personal privacy outside of the general criminal justice, like Weeks and the others ones we were talking about, Chris.
Right.
To me, and again, I and this is the problem. To my knowledge, and am I wrong here, gentlemen? The Supreme Court has never referenced a standalone Ninth Amendment right. Am I correct on that?
Yeah.
And why is that? Is that because is that Tim's explanation? Madison just kind of threw it out there and said, "Leave me alone."
Well, Justice Stevens had an answer. We had the privilege of meeting with him once.
Go ahead.
Someone said, Justice Stevens, why is the court historically stayed away from the Ninth Amendment? With the exception of Goldberg's Flight of Fancy and Griswold. And sorry, I just had to get that in, Chris. So Steven, this is what he said. He goes, "Oh yeah, the Ninth Amendment. I think I have a book on my shelf about the Ninth Amendment somewhere." So everybody chuckles, and he goes, "No, the honest answer is both liberals and conservatives are scared to death of opening up Pandora's box. That's why nobody nobody wants to touch it." And that's one justice's opinion.
Yeah, but think about this, and I'm to push back just a little bit. And we've talked about this other phrase in the 14th Amendment, privileges and immunities,
right,
and how that was killed in its crib and slaughterhouse, right? But we know that privileges and immunities were written extensively at the founding. They were prior to that. They're in English law. The idea is the privileges and immunities of citizenship that entails. But because we had one case that the court shot it down, so people have shied away from it. So they found other places to hang their argument. And I would say the Ninth Amendment is there for a reason. With my students, I always call our safety net, right? Because we can't write down every right. We just can't. And back to your point is well made about Madison and his nauseous project. So let's have a safety net, because there might be things we haven't considered yet, and because we don't have judges or justices that are courageous enough, doesn't mean we shouldn't be using it. Because if you look at where we are now in the expansion of rights in this country from the beginning to right now, we've had to hang arguments on due process in the 14th Amendment, right? Or equal protection in the 14th Amendment. And I just, those aren't always great arguments. But Mike, I'm sorry, go ahead.
No, don't apologize at all. That's wonderful. I've been thinking a lot about this idea of personal autonomy that Dave mentioned, and trying to square that with either my understanding of privacy or what's in our text. And let me just run with this for a second, see if it goes anywhere. Because it seems to me like this notion that I said a minute ago, like the right to be left alone. You see that. I think you see that in the Third and the Fourth Amendments. Like you see this idea of like, there are certain spaces where I should just do whatever I want, as long as within boundaries, right? And that to live in a constitutional republic, that should be the starting point, right? Personal autonomy to me, when I hear that phrase, I think about not doing something where all my doors are closed. It's having a choice of how I move through the world, how I move through the public world. And I'm just thinking, I'm thinking about, in the 1890s, 1870s, 1890s, the Supreme Court's ruling that women cannot practice law, right? When you think about personal autonomy, how does that square with slavery? Or how does that square with being told you can't sit on certain trains, certain parts of trains? So to me, I don't know if they're the same. I think they're related, but my guess is that the founders would be much more comfortable with this notion of leave me alone in some designated space than somehow having a right to move through the world in my own special, unique way. I see those as two different ways to think about privacy. Does that make sense to anybody?
Well, let's build that bridge. So if you look at the gay rights movement and gay marriage, how would you designate that, Mike? Leave me alone, or is it my autonomous right to decide how I live, and government has no legitimate interest to decide who I have sex with, who I love, who I marry?
I think I haven't thought about this, so all the viewers bear with me. I see the right to have consensual sex with who you want, to me, would be a private matter.
Right.
Okay.
It's not autonomy.
To me, marriage is autonomy because marriage is something that you do. It's public. Like I think there are rules about having consensual sex in public. I'm guessing most of our
Sure, but that's not again.
There
Public
are?
is not private. Yeah.
Stop.
I see the two as a little bit distinct.
Gentlemen, you want to jump on this train or
No. I certainly don't want to jump on that train.
What Mike's be talking about, and I thought hopefully students that have been dealing with this question have already looked up Olmsted. Olmsted v. United States.
Yeah, thank you, Chris.
And Brandeis is the right to be left let alone is the most basic right of civilized men, I believe is the quote from Brandeis in that opinion. So that's that's a really important concept to get. So I think I agree with Mike, right there. I mean, let's face it, there are just certain places, and Lawrence v. Texas, right, is a great case to look at. That there's certain places the government doesn't belong, and Griswold to Roe, which is a case we've not mentioned yet, Roe v. Wade, is part of that. There's certain places where the government simply doesn't belong. And David, you mentioned that earlier in that zone, right? That there's we're carving out this idea that there's a right for the government not to be in certain places. And I think there's so much case law on this that holy cow.
Well, that feeds into what I was going to ask you, Chris, but I think you've kind of already touched on it, is the consistency of the court dealing with privacy. And I guess your response is because of the nebulousness of the very concept of privacy, because it's not enumerated or articulated in any clear way within the Constitution itself. And I think we'd all agree, even Fourth Amendment, all right, implications of privacy rights have been whittled away since the 1980s, right? If we look at search and seizure and then, and the reasonableness standard, how many exceptions are there now to search and seizure clauses, in which to me we've just kind of destroyed the whole idea that a man's home is his castle, concept of privacy there. So I guess you would agree, Chris, that the court hasn't been consistent because and here's part of my question is wasn't Veronia a drug testing plan by the school district?
Yes. Yeah.
And I'll be honest, I was shocked by that the court upheld the district plan because really without probable cause,
Well,
we can test people.
This, in a way, this kind of goes back to one of our last episodes when Tim talked about the exception, right, in Tinker. However, if the school believes they need to take an action for, I don't know, throughout the common good or for the protection of students, right, they have the certain ability to do that. If that means limiting speech, yeah. But then we're talking about, okay, we have a severe drug problem at the school. We believe it's members of an athletic team. We would like to actually start searching. We have, random drug testing, and the courts believe that was there's a lower expectation of privacy for athletes. So and you go from there to a series of drug testing cases. I think the last one was the Earls case, EARLES, out of Oklahoma, which gave basically the schools a wide parameter for drug testing.
I've been thinking, Mike's point, my mind's going 1,000 miles an hour on this distinction that he's tossed out for us. This personal autonomy. I wonder if the tremendous emphasis of late meaning, say, I don't know, the last 50, 60 years on the meaning of privacy, meaning personal autonomy. I wonder if it's connected to a cultural shift to a very an extreme emphasis on individualism automatically gets us to personal autonomy. Whereas I don't know, maybe I'm guilty of a good old days mentality here, that prior to World War II, there wasn't that tremendous, there was more classical republicanism in our heads than libertarianism in our heads. And so after World War II, and certainly since kind of the cultural upheavals of the 60s and the emphasis on the individual, is it easy to get to this idea of personal autonomy given a cultural shift to the emphasis on the individual?
Yeah, I would say it's actually, yes, I'm agreeing with you, but I think it's different because I think we see it as an expansion of liberty. I see this shift is not as a contraction, but I see it as an expansion of liberty for so many people in our society that have been ostracized because of who they love or how they love, right? Or their government in their business or society in their business. So you think about in the 1950s, if you couldn't be a gay or lesbian and be out and work for the government because you'd be considered a security threat. So I think that, yeah, we may be part of that, Tim, but I'm not saying, I don't think that's necessarily a bad thing because I see it as an expansion of rights. I mean, we get into the current.
Well, I wasn't making any normative.
Yeah,
I wasn't making any normative statements about it. I just wonder, is there a relationship to this tremendous emphasis on it, given the tremendous emphasis on individualism post World War II?
Sure. It seems like a very 60s kind of thing. Does that make sense?
Well, when it comes, and again, when we talk about personal autonomy, I think, we're talking about Griswold, we're talking about Roe, we're talking about Lawrence, we're talking about Bowers, we're talking about, really, I hate to say it, but they generally are, something to do with reproduction or sex. And what interest does government have to be involved? And that's government. That's the state action doctrine of the 14th Amendment. When we get to technology and those issues, is it more complicated now? Does the state action doctrine even apply when we look at privacy and technology today? And I guess, Mike, because we're coming up to the end here, I guess I want to go around the table here and ask each of you what you think is the most concerning issue, keeping in mind this state action doctrine, which prevailed for quite a long time there, but to identify what you consider the most concerning privacy issue of our time here. And Chris, you had something.
I just for the students watching, the state action doctrine is the idea that it has to be the government action in terms of a limitation of your rights, not a private company. So, if you get fired and you're an on-air personality, you can't claim, well, that's a violation of my First Amendment rights. No, the network fired you because you showed up without pants, that kind of thing. So it's a state action is the government limiting the right.
And it gets a little bit more complex when you talk about private business who has contracts with the government
Right.
and stuff. So what has been defined as state action is a little bit more expansive than maybe what was originally understood.
Can I just
Go
throw
ahead,
out,
Mike.
I just want to throw out to the students that we kind of take that as the norm, right? That our Constitution is about limiting government to not harm us. But that's not the only way it can be. And again, countries like South Africa say we have all these constitutional rights and no one can infringe those. So a person or a company can't infringe those. They've just written it into it because they don't want to see any circumstance where someone's freedoms are being taken away. So I just wanted to add that in. It doesn't have
Well,
to be.
and they're kind of feeding off the American experience because the United States Congress tried to regulate some private behavior and discrimination with the Civil Rights Acts in the 18 and in the Civil Rights cases of 1883. That's what really defined the state action doctrine and said, listen, if a carriage or a taxi or a motel or a restaurant wants to discriminate, well, they can there kind of stuff. But again, Mike, coming to the end of the program here, what do you identify as the most serious in kind of the categories I have? Is it the surveillance state? Is it the power of big tech companies? Is it personal autonomy? And obviously, I'm referencing gay rights and reproductive freedom there, or is there some other item I haven't mentioned?
Yeah,
no. You think?
Yeah, no. To me, it's the combination of big tech and the surveillance state. So I'll just have the students think about this. Think about like the time of our founders, right? They would write letters to each other. And the biggest fear they might have is someone would intercept those letters, read them, right? And know what they were writing, okay? Now we're to a point where it's even beyond email, right? I can write a very personal email to one of my 3 friends here, right? But it's technically because of some consent form I've already signed. I don't own that email, right? And it gets
is that outside of your USD account?
I'm sorry, USD owns my emails there, and Google owns my emails at Gmail.
Really?
That's part of when we sign up for those services. That's what we're saying. And
that's that fine print stuff that I never read. Is that what you're telling me?
So, and I'd have the students think about one thing that's already happened, right? We know that the National Security Agency ordered Verizon to basically give them phone records as part of their surveillance after 9/11. So we know that's already happened, right? But just think about if you have a device in your house, like I don't want to say the name because then she's going to talk to me, right? But Alexa, right? Those devices they could be listening to our conversations. And then whoever owns that device, I don't even know for sure who owns it, but imagine as our homes become more technologically advanced and our refrigerators are computerized and our security systems and all of our conversations, I think that there is a real threat there's a real threat to our privacy based on that and what the government could do when they get their hands on that. So sorry, I went on too long, but that's my thought.
No, not at all. Professor Kavanaugh? What do you see as the most
I was thinking about that until David, you said a couple of things, so I'll get to that. But I agree with Mike about that because, we don't, and David, you jokingly mentioned it, because we never read terms of service, right? We just want to play Texas Hold'em on our phone, or some of us do. Or we have a device that, is listening constantly, and who's actually recording that and who actually owns that. Do I have an expectation of privacy in my home now that I have an AI device in my home? So we don't even know. And think about it for the students. We're using something that was ratified in 1791. We're using stuff from 1791 to figure out if that device that's listening right now is like, who owns that, which is crazy. This is why I think that data privacy is an issue. But David, you mentioned something too, and there's a case coming up that the Supreme Court is going to hear out of Mississippi on abortion rights. And, we thought that was kind of settled to a degree. And it looks like there's a chance we may go backward on that. And I think that is a huge issue right now because if you look at opinion poll after opinion poll after opinion poll, the majority of Americans do not want to go backward in terms of that kind of thing. So I think that is a big issue as well as electronic privacy.
Mr. Moore?
Yeah, I think the informational data complex is a real problem, to echo my colleagues here. I mean, it's staggering what, and I don't follow it much, but it's really, really staggering to me, everything we've learned about how big tech uses algorithms. I mean, it's just staggering. In fact, I would suggest it's probably I think it's more problematic than government intrusion, frankly. So I would echo that sentiment that we're, the big issues I think are private data.
Well, and again, I can't disagree, although I'm not involved in tech as far as I don't play things on any device. You just surprised me with the email and how accessible that is. There, see, that just shows you how much of a troglodyte I am when it comes to.
You know that YouTube is not a private channel just for us, right?
Yeah, I got that. All right, I did get that. Thank you, Professor Williams. That's right there. But given the current circumstances and the case in Mississippi, as Chris mentioned, and also the situation in Texas, also it shocks me that there are over 20 states that still don't provide, equal rights to gay and lesbians in the workplace or in education facilities in many cases, which to me is also a privacy issue because, it's irrelevant to me that the state has any, the state should have no interest in what goes on in your personal relationships as long as it doesn't involve children underage. There, I just don't get the state interest. But we're also seeing states now picking up on overturning Griswold, in the area of reproductive freedom and trying to criminalize, birth control. I mean, this is just shocking to me. So, I tend to lean to those, although the whole big tech thing, and like I said, that gets complicated as far as government goes on their ability to regulate because of the state action doctrine. I mean, how much power does Congress have to address Facebook?
They did it in the progressive era. They figured out a way to argue against the private ownership of your business that has no relevance to the public. They figured out how to do it in the progressive era.
And that's the Commerce Clause.
And for students, think about this. Can you function in society today without these or without, what we're doing here using the internet? So the idea is that you could, right? But you're going to be limited because how many applications do you fill out online? All the things you do now, especially in a pandemic, right? So the access to tech in today's world is essential. Much like I think of like property rights when you think about the founding era.
Yeah.
So this is where this also is it's hard to function in today's society and cutting the cord.
Yeah, I had this colleague at University of San Diego who was a communication studies professor, and I used to lecture with him to incoming first years every year. And he'd always do the same lecture. It would be all about the internet and all about emails, and his point was kind of just like that this generation of young people now, they've just grown up with it, but they really don't know what they're doing. Like we pretend like you know how to interact with the technology and you know that the possible pitfalls there, right? And his point is always just like, you need some basic like 101 lessons about what it actually means to be using this. Because I think all of us, like Chris said, we just go in, I just want access to my whatever app, and I will hit yes, 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 because what could go wrong, right? And I mean, how long is that sustainable for? Seriously.
There's a great
Well,
book. There's a great book written by Neil Postman on this very question. It's called Technopoly. And a lot of the issues that we're talking about, and this was like the early 90s, he talked about all this. It's still a pretty prescient book, I think. I'm in the middle of rereading it again, but it's fantastic to address those kinds of issues, to Mike and Chris's points.
Well, this is a topic, students and teachers, that we really wish we had more time on. We've barely touched the surface on this, which was the challenge itself in the question. Hopefully we've given you some direction, some things to think about and gnaw on when it comes to privacy and the myriad of issues that we confront in that sense. Next time that we meet, we'll be talking about the criminal justice system and the right to trial by jury and the myriad of issues that go along with that, and talk about, again, a right topic. If you've been following at all the news, you've got a trial up there in Kenosha, Wisconsin. You've got a trial in Georgia. Both of them have implications of the jury and the rules of due process when it comes to trial by jury. So until next time, the 4Bs do recommend fairly soon. There's going to be a documentary coming up by Peter Jackson on the Beatles. And since this will allow you to say, okay, boomers, I don't know if that's now passe, but we suggest that all you young people watch this documentary by Peter Jackson. And I want to say something. Alexa, play I'm So Pretty in Mike's House. No, it didn't work, kind of stuff. Until next time, peace, love, yogurt tacos. Bye, 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 bonds.